In this video, I'm going to discuss 5 different documents that have been submitted to the United Nations and have been disseminated by the Secretary General. Here's the first one, and it's regards to Peru, and it's a notification under Article 4, subsection 3 of the International Covenant on Civil and Political Rights. And the other 4 documents are also pretty much the same. They're notifications under the same covenant. This one's also by Peru. The third one, also by Peru, and again, International Covenant. The fourth one is also Peru. Same thing, International Covenant. And then the fifth one is from Chile, and it is also a notification under Article 4, subsection 3 of the International Covenant on Civil and Political Rights. All 5 of these documents are notifications under that International Covenant of Civil and Political Rights. I'm going to talk a little bit about this International Covenant, talk about the United Nations role with regards to this, and then also discuss why these notifications have been issued by these countries. All right, before we get into the substance of the notification, let's take a look at what United Nations organ entity is involved with these notifications. Here it says that the Secretary General of the United Nations, acting in his capacity as depositary, communicates the following. So somehow the Secretary General is involved. What is the Secretary General? Well, here if we go to the UN Charter and we look here at Chapter 15 is the Secretariat, and in the Article 97 says that the Secretariat shall comprise a Secretary General and such staff as the organization may require. The Secretary General shall be appointed by the General Assembly upon the recommendation of the Security Council. He shall be the Chief Administrative Officer of the organization. So the Secretary General is the Chief Administrative Officer of the Secretariat. And going on to our UN systems chart, here is the Secretariat there as one of the 6 principal organs. All right, so what does this notification have to do with the Secretariat? If we go back to our charter and we look at Article 102, that's an important provision here. It says that every treaty and every international agreement entered into by any member of the UN after the present charter comes into force shall as soon as possible be registered with the Secretariat and published by it. So one of the duties that the Secretariat has is that anytime some treaty, international agreement is signed and entered into force, it's deposited with the United Nations, and the Secretariat is the one that's responsible for receiving that and organizing it into some fashion so that anytime there are provisions within the treaty that need to be dealt with, the United Nations and the Secretariat is the one that handles those responsibilities. All right, let's take a look now at the website for the United Nations and let's see what it has to say about the Secretariat. Secretary General. Go down here, we've got the Secretary General and the Secretariat. We'll check out the Secretariat. Here is their webpage, and it says here, just like it says in the charter, the Secretary General is the Chief Administrative Officer of the UN and head of the UN Secretariat. So the Secretariat has a bunch of offices underneath it, one of which is the Office of Legal Affairs. Let's check this one out. This is the Office of Legal Affairs, and let's see who the legal counsel is. It is this gentleman, Mr. De Serpa Soares, the Undersecretary General for Legal Affairs. He is the legal counsel, and he was appointed in September of 2013. He was Director General, Department of Legal Affairs, the Ministry of Foreign Affairs of Portugal from 2008. Served as a member of the Permanent Court of Arbitration in The Hague since 2010. So that's just a little bit about his background, and then going back to the Office of Legal Affairs, we see that it has some divisions within it. Within it is one division is the treaty section, and the treaty section is the one that actually handles the receipt, the organization, and communicating to other member states with regards to treaties. And so this is the treaty section is the one that is actually dealing with our document here. When it says the Secretary General, they're just referring to the treaty section. Now we'll watch a quick video clip of UN Legal Counsel Miguel de Serpa Soares talking about the treaty section and the explosion of all the multilateral treaties that have happened since the UN was created.
We have much more treaty law now than we did before the Second World War. Does that figure in your work much?
It does, and I would like to add is one of the major achievements of the United Nations, and it also it shows in a way how much the international order has changed since 1945, because if we look into the past, most of international law was either customary law or bilateral treaties. Mostly in trade relations between two countries or matters of war and peace. And it's only after 1945 that you have this eruption of this multilateralism. I think more or less, roughly, we have 560 multilateral treaties concluded under the auspices of the United Nations.
And here are those 560 some odd multilateral treaties deposited with the Secretary General. This is from the treaties.un website. The link is in the description. And here, all of those treaties are organized into chapters. For example, here's chapter 4 is human rights, and if we click here, we can see here they have 16 separate instruments under chapter 4, human rights, and we'll look at another one. Let's go to economic statistics, chapter 13, and there are 3 or 4 here. Protocol amending the International Convention relating to economic statistics, signed in Geneva, 14 December 1928. So this is even before the United Nations was created. So that gives you an idea of these treaties and how they're organized and kept.
And some of them are absolutely instrumental and fundamental in the international order. So I think that's one of the big achievements. I take that part seriously in the sense that we keep promoting multilateralism. And each year during the General Assembly, there is one event which is called the Treaty Event. It's basically organized by my office. And in this event, we invite states to come and sign and deposit ratifications of multilateral treaties.
All right, let's get into our document. This is, again, a notification under Article 4, subsection 3. And Peru is the country that's giving the notification. And it's in regards to the International Covenant on Civil and Political Rights. So what is exactly this covenant? Let's take a look here. Here is the actual covenant, and this is from the United Nations Human Rights Office of the High Commissioner, and this is from their website, and they have a nice, just a full page website on the document itself. And so we'll just take a look at a few provisions here, and this gives us an idea actually what this covenant does. It starts off in the preamble, and that it says that that this covenant, it recognizes the inherent dignity and of the equal and inalienable rights of all members of the human family, and is the foundation of freedom, justice, and peace in the world. So this starts off pretty strong. And for those of you that enjoy reading the U.S. Constitution, the Bill of Rights. This document is kind of mirrors it, tracks, is very similar to it. And let's take a look at a few more provisions. I just highlighted a few. Okay, everyone has the right to liberty and security of person. Anyone who is arrested shall be informed at the time of arrest of the reasons for his arrest, shall be promptly informed of any charges against him. So, whereas this is looking more and more like something like the U.S. Constitution, the Bill of Rights, the protections that the U.S. has and promotes. In fact, there's a big movement. A lot of people believe that the rest of the world should have these rights. And we'll see in this document that they actually do through their country signing, ratifying this covenant. All right, a few other provisions. Accused person shall, save in exceptional circumstances, be segregated from convicted persons, shall be subject to separate treatment appropriate to their status as unconvicted persons. Right, so just because you're accused of a crime, arrested, you shouldn't be really put in the population of people who are convicted of the crime. And another one, no one shall be imprisoned merely on the ground of inability to fulfill a contractual obligation. U.S. has the similar provision. You can't be put in jail for a monetary debt obligation. You have the right to liberty of movement, freedom to choose his residence. Person shall be equal before the courts and tribunals. Everyone charged with a criminal offense shall have the right to be presumed innocent until proved guilty according to law. Have adequate time and facilities for the preparation of his defense. Communicate with counsel of his own choosing. Not to be compelled to testify against himself or to confess guilt. No one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honor and reputation. Everyone shall have the right to freedom of thought, conscience, and religion, basic rights that the U.S. has. Everyone shall have the right to freedom of expression. So those countries that we think of as repressive and don't allow this, actually they do. Maybe it's not implemented or executed with the same way it is in the U.S., but nonetheless it's there. The right of peaceful assembly shall be recognized. Everyone shall have the right to freedom of association with others, including the right to join trade unions for the protection of his interests. And so those are just a few, and we'll go into other parts of the covenant. And one more thing is, if we go back over here to the UN Treaty Collection website and we look up that International Convention Covenant on Civil and Political Rights, they have a list of the countries that have signed and or succession, ratification. And here they are, and you'd be amazed at the different countries that are probably seen as repressive have signed and ratified the document, and so they are they need to uphold their obligations in there. And like, for example, just we can see the Russian Federation is there, Rwanda, Sierra Leone, Somalia, South Sudan, even Iran, Iran, Iraq, and others, So this website shows you all the different countries, and so you can see which ones have signed and ratified. All right, now let's take a closer look at the Article 4.3. So here's Article 4, subsection 3. Any state party to the present covenant, availing itself of the right of derogation, shall immediately inform the other states parties to the present covenant through the intermediary of the Secretary General of the United Nations. And so what they're doing here is they're notifying the Secretary General of their right to derogation. And subsection 1 is kind of describes that right. So it says that in time of public emergency which threatens the life of the nation and the existence of which is officially proclaimed, the states parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. Okay, so in order to derogate, they need to, number one, immediately inform the other states' parties through the intermediary of the Secretary General. And in that notification, they have to state the provisions from which it has derogated, and number three, the reasons by which it was actuated. And now turning to the notice here on the left side, we have that the permanent mission of Peru presents its compliments, in accordance with section Article 4. It has the honor to report the following. By Supreme Decree number 13, 2024 PCM, published on February 6, the government of Peru extended the state of national emergency declared by Supreme Decree number 23, 2023 PCM in the provinces of Putumayo and Mariscal Castilla of the Department of Loreto for a period of 60 calendar days starting on February 13. The measure was declared owing to the illegal activities of criminal organizations involved in illicit drug trafficking, illegal mining, and related offenses. So I think it'd be easier. I went ahead and I just put them all in a spreadsheet, these 5 notifications. 4 of them are from Peru, 1 is from Chile. The 4 from Peru, the reasons why they notified the United Nations of the derogation of the ICCPR. The 4 reasons they give: preserve internal order and to guarantee the constitutional rights of the population, to combat and neutralize illegal mining and related offenses that have a negative impact on the normal activities of citizens in the aforementioned areas, in view of the continuity of terrorist activities and the commission of other illegal activities in the aforementioned areas, owing to the illegal activities of criminal organizations involved in illicit drug trafficking, illegal mining, and related offenses in the aforementioned provinces. And those places are here. We have the southern road corridor of Apurama, Cusco, Arequipa, Tambopata, and others here. Let's widen this a little bit. And then here in this particular one, in this one is number 64. We've got quite a bit. We've got 37 different, all these departments, provinces, and then within those provinces are all these districts. So there's 37 of them. Again, continuity of terrorist activities. And finally, this Putumayo, Mariscal. So Peru seems to have some issues with some illegal criminal activities. They're calling them terrorist activities. And then finally in Chile, they're saying it's in response to the forest fire. So these criminal activities that are happening in Peru are not really carrying over to Chile. It seems to be completely separate. So Chile is doing it in response to the forest fires in the area that have affected nature reserves, infrastructure, and residential areas, with serious consequences for the life and integrity of the persons affected. And that's the reason why Chile is giving the reason for the derogation. And I saw a news article that actually talks about maybe it's in response to a different reason. And let's take a look at that right now.
Visiting a rural community ravaged by wildfires, Chilean President Gabriel Boric consoled residents, promising aid to thousands of affected families. He also addressed fears of arson amid reports of people trying to deliberately light new fires.
We have appointed a colonel for each county who will be in direct contact with the mayors, who will tell them exactly which area needs special patrolling. We know that improving a sense of security is very necessary to prevent uncivilized behavior of miserable people.
Residents here say they're still in danger after surviving last weekend's wildfire.
Last night we discovered a tree trunk on fire. It didn't catch on fire by itself. It happened right when two strangers were seen roaming the entrance after curfew.
Navy special forces are being deployed on land and air on the lookout for arsonists who are suspected of having started a wildfire last Friday that destroyed entire neighborhoods. There's still a lot of questions as to how and why the worst natural disaster in Chile since the 2010 earthquake took place. The government is asking the European Union for assistance because of its expertise in wildfires, especially in highly populated areas. But the people who live here say that there are other things that need to be taken into account. They're referring to an incentive to burn land.
Cosas de hecho, lo hemos visto.
Everyone can see that whatever forest or agricultural land has been ravaged by wildfires, soon after the land is sold for housing projects. First the fire, then the sale of the lots.
I asked the Deputy Interior Minister about the allegation.
For some time there's been a bill in Congress that would declare areas impacted by fires ineligible for building projects. It's unacceptable that there be a perverse incentive for wildfires to benefit private economic interests.
Others are pushing for the government to increase penalties and try arsonists as terrorists. Whatever the cause or the motivation behind these fires, the outcome has been deadly. Lucia Newman, Al Jazeera, Via Alemana, Chile.
All right, so let's go back to the notification. Chile says that in these provinces, they're going to have to derogate from their obligations under the covenant, and it's in response to the forest fires have affected nature reserves, infrastructure, residential areas, serious consequences for the life and integrity of the persons affected. And then what they do in this notification is they actually cite the specific article in the covenant which will be derogated from, and that's the right to liberty of movement as provided in Article 12. And if we look real quick, Article 12, there it is. Everyone lawfully within the territory of a state shall, within that territory, have the right to liberty of movement. So they're telling you this is the specific right, and what even more specifically, there's going to be a curfew on Saturday, Sunday, and they actually give the exact dates and times. And they said that the purpose is to keep roads clear for emergency vehicles and for the purpose of evacuations. And then they say it may be renewed, and in addition, other restrictions may be adopted in the coming days. So I would be pretty concerned here. The concern that I have is, are they going to use it for other means? And that's one of the things that the Human Rights Committee actually discussed with regards to this particular, with the derogation clause. So, but it's important also to remember that in order to do a derogation, the covenant itself says that this public emergency has to threaten the life of the nation. So that, I don't know, as a small fire in the mountains outside large cities, does that threaten the life of the nation? Well, the Human Rights Committee probably realized that this is maybe a little bit ambiguous and vague, and so they issued what they call a general comment, number 29, and they discussed this, and it's on Article 4, a comment on Article 4, and here's 17 or so paragraphs discussing it, and this kind of gives you a little bit of background, what they feel is the intention, and getting more in specifics as to what this comment means. And I just highlighted a few provisions here where they talk about here they say that before a state moves to invoke Article 2, two fundamental conditions must be met. The situation must amount to a public emergency which threatens the life of the nation, and it must have officially proclaimed a state of emergency. So we saw in that notification, Chile did proclaim it a state of emergency through, I think, their Supreme Court decree. And then, but they say, hey, it's got to also threaten the life of the nation. So what does that mean? And here they say, not every disturbance or catastrophe qualifies as a public emergency which threatens the life of the nation. So here we go. There is a line, but they don't know exactly where that line is. But there is a line as to when a particular disturbance or catastrophe qualifies as something which threatens the life of the nation. Does this particular wildfire do that? I'm not sure. So they go into a little bit more. It must be limited, and then the derogation must be limited to the extent strictly required by the exigencies of the situation. So it has to be just related to the fire, once the fire is out and it's no longer danger, then they can no longer have that derogation. And it has to, and that's with regards to the duration of it, the geographical coverage, and the material scope of the state of emergency. And here they say, there's a little bit more discussion about the natural catastrophe, which this wildfire is. It must be able to justify not only that such a situation constitutes a threat to the life of the nation, which I don't think it has, but also that all their measures derogating are strictly required by the exigencies. In the opinion of the committee, the possibility of restricting certain covenant rights under the terms of, for instance, freedom of movement, Article 12, which this is the derogation notification at hand is Article 12. And this must be generally sufficient during such situations, and no derogation from the provisions in question would be justified. So what I believe they're saying here is that, hey, look, you don't even need to derogate in these situations where there's a natural catastrophe, and all you have to do is just restrict the rights of freedom of movement, and that's generally sufficient during such situations. However, they still have to justify that it constitute a threat to the life of the nation. I don't think it has. All right, let's continue. And then no derogation from the following articles may be made. We already know this. These are articles from the covenant, which doesn't matter what the situation, what the catastrophe, what the threat is. There's in no circumstances can a state derogate from these articles here. Let's see one more. And then a state party availing itself of the right of derogation must immediately inform the other state, which it has done through the UN Secretary General. And the notification by states parties should include full information about the measure. So it looks like Chile has done that. Also, before this comment was issued, the Human Rights Committee did have a meeting, and there was some discussion about these issues. And I have a little bit of it's not really a word-for-word transcript of that meeting, but it's more of like just a record, a summarization. And so there's a few things that I took down here. There's a Mr. Henkin who was on the committee. He said he had doubts as to the breadth of the concept of threats to the life of the nation. So even he doesn't really understand it. He's not sure where to draw the line, how to articulate it. To interpret as referring to external attack was to limit it. Natural disasters also posed a threat. So they're saying that it can't just be another country or an armed conflict. It is saying that natural disasters also belongs in that category as to qualify for something to have a derogation. But here he says, but in most cases, not to the life of the nation. Natural disasters do not threaten the life of the nation, and this is an admission here from Mr. Henkin. On the other hand, not only natural disasters, but also terrorism often pose a threat to a region. Regional disturbances were often dealt with by the imposition of martial law, yet that was not the same as a state of emergency. The interrelationships between such concepts need examining. So they have to examine it further. It's not very clear. Not sure exactly how to articulate it. Then there's Mr. Amor. He says that, or she, that to preserve certain fundamental human rights, even in states of emergency, but also to preserve the life of the nation, the committee should reflect on the use made, not so much of states of emergency in strictly legal terms, but rather of the exceptional powers conferred by such situations. So we have to be mindful of, hey, we're giving a lot of power to these states to just unilaterally just decide, oh, we're just going to suspend our obligations under the covenant. Sometimes they serve simply to justify systematic violations of human rights. The phenomenon has been observed in a number of states, including one which had a state of emergency in force for over 30 years, from 1965 until quite recently. So here you go. He's here, Mr. Amor. Mr. Amor is saying that, yes, in fact, we have to be careful because some states might abuse this right. And then finally, there's one more comment here. Mr. Wierachewski, he says that he also is concerned, like some earlier speakers, because he came from a country which had experienced a period of public emergency. At the time, he had been approached with a request to produce a legal justification for the imposition of martial law, which he had refused to do. But he takes a different view of this, not so much as let's try to define what constitutes a public emergency that threatens the life of the nation, rather just concentrate on the issue of non-derogable rights. So which rights cannot be derogated from, instead of going to the life of the threat of the life of the nation. While fully aware of the problems referred to by Mr. Amor, he felt that the committee's main purpose should be to try to identify those rights. So forget about trying to draw that line of public emergency which threatens the life of the nation. Just forget about that. Let's just concentrate, identify those specific articles, those specific rights which cannot ever be derogated from. All right, and then the next thing I just want to show you is these notifications by the country of Peru. This is notification number 62, and here they say that's the Apurama, Cusco, Arequipa, Southern Road Corridor. And this one doesn't really get into the specifics as to why, but they're just saying we're declaring the state of emergency to preserve internal order to guarantee constitutional rights of the population. I don't see any finding that the life of the nation is in jeopardy. So here they name the articles 9, 12, 17, and 21. It's relating to liberty, security of person, inviolability of the home, freedom of assembly, movement in the territory. And then this is notification number 63, different provinces and districts. This one is to combat and neutralize illegal mining related offenses that have a negative impact on the normal activities of citizens in the aforementioned areas. Again, similar to number 62, Articles 9, 12, 17, 21. Again, no finding that the life of the nation is threatened. Next notification is number 64. And this one is there's a lot of districts here, 37 of them. And then they're saying that the state of emergency has been extended in view of continuity of terrorist activities, commission of other illegal activities. Again, this is pretty general. This certainly should be scrutinized by the Human Rights Committee. Again, the same articles 9, 12, 17, and 21. And the last notification is number 65. And this one, 2 different provinces. Owing to the illegal activities of criminal organizations involved in illicit drug trafficking, illegal mining related offenses. Again, same articles 9, 12, 17, 21. Don't see a finding of the life of the nation is under threat. All right, last thing to talk about is the Human Rights Committee. The Human Rights Committee was set up under the covenant in Article 28. If we look at that, it says there shall be established a Human Rights Committee, shall consist of 18 members, carry out the functions hereinafter provided. And there's quite a few, but one I'll touch upon. The states party to the present covenant undertake to submit reports on the measures they have adopted which give effect to the rights recognized herein and the progress made. If we go over here to the Human Rights Committee membership webpage, here are the current members, 18 of them. You can see Paraguay, Azerbaijan, Egypt, Costa Rica, Spain, Serbia, Japan, France, US, some of the members of the 18 members. And then one other thing we're going to look at is they have a nice website here, and it's in the links section. If we go to this website, countries, we can look up every country and the reports that they submit. Part of the requirements as a state, a member party to the covenant, is these periodic reports. And let's take a look at, for example, Peru. And here's, if we go to status and reporting, and we look at reporting status, opens up this page here. And here we see under the internet, these are all the human rights treaties, but here the International Covenant on Civil and Political Rights, we open this up, we see all the reporting cycles that they went through to talk about their compliance with the Covenant on Civil and Political Rights. And we could take a look at, let's look at 2017. Here is a list of issues prior to reporting. So this is the committee itself sending some questions, requests for information to Peru. And one of the things they talked about was the not so much the document that we just discussed, but there is Article 4. They want to know, please provide information on the harmonization of national legislation on states of emergency with the conditions set out in Article 4 of the Covenant. So Article 4 is the derogation. So they asked Peru to go ahead and give more information about that. And now we'll look at their Peru's response. And we open up this document in English. And this is the 6th periodic report. And if we look at emergency, states of emergency, and then here's some of their responses with regards to that. And it talks about that under their laws, the president is authorized to order states of emergency, and they go into some of that detail, and not necessary to look at it right now. Last thing I want to show is the actual Human Rights Committee meeting. I think this was in November of 2023, and this is the closing of the session. And just want to take a look at just an example of the meetings that they have. And there's some nice closing thoughts, especially from Mr. Amadov, who just gives a general opinion and recap of what the Human Rights Committee does and what it experienced recently.
Good morning, colleagues. We are in an open meeting, and this is the 4075th session of the Human Rights Committee.
Thank you very much, Chair. I really would like to thank the colleagues first and foremost. And thanks particularly especially go for their intellectual tolerance. Because this committee consists of 18 members that come from completely diverse traditions, backgrounds, cultures, legal traditions. And reconciling the views of 18 people with such diverse backgrounds is extremely difficult. This requires a highest degree of intellectual tolerance and culture. We have been able to, in this committee, at least during this session, to adopt a view having a pendant 11 separate opinions. So this, I think, requires a juggling of intellectual juggling of a completely different degree. And I think this really shows that the committee has been, throughout this session and before, has been very much committed to the work it has in order to be able to put aside all their personal differences at times and to be able to work towards that ultimate objective of protection and promotion of human rights.